All right, you're dang fine.
Everyone please see. They cross the boundary.
Good afternoon, Doctor.
Afternoon.
You've had a clinical and a forensic psychiatric practice for 30 years, sir?
Yes.
And you've testified in that field in Hillsborough County, Pinellas County, just to our west across the bay, Polk County just to our east, to our north. Now that would be in Pasco to our north and Polk to our west, and regardless of whether I have the geographic needle pointed the right way. But you've testified in all of those counties and others in Florida, correct?
Yes.
Can you tell the jury the last time you testified on behalf of the state of Florida or on the issue of criminal defendant's sanity on behalf of the state?
I have not.
And how many times have you given your expert opinion as to sanity of a criminal defendant facing charges in a criminal court on the issue of sanity?
I'm not sure. I would estimate maybe a dozen times.
Okay. And in addition to testifying a dozen times for a criminal defendant on the issue of sanity, can you tell us how many times you have been retained by defendants facing criminal charges to assist them in the preparation of their defense, contemplating mental health defenses to include insanity?
That would be a little harder because it's a little bit ambiguous, but probably a couple hundred times.
Okay. On February 21st of 2011, or 25 days after Julie Schenecker killed her 2 children, you spoke to the defendant in the Hillsborough, in person, right?
Yes.
Okay. And at that time, which was your first interview of the defendant, correct?
Yes.
At that time, she told you unequivocally, without ambiguity, without exception or reservation, that she went to buy the gun with the knowledge that she was going to use it to shoot herself and her children. Isn't that correct?
Yes.
And it was your belief as late as April 13th of 2013 that the defendant bought the gun with the knowledge that what was going to happen with that gun is that she was going to kill herself and take her children with her. Isn't that correct?
Yes.
Did you ever talk to her about why she drove 27 miles to Oldsmar to buy the gun?
I did raise the issue. I never got a response that I could make a lot of sense out of.
Did she give you, even though it was maybe nonsensical, did she give you an explanation or a reason as to why she had to drive from Tampa Palms across Hillsborough County to Pinellas County to buy this firearm?
The best that I can remember is that she was looking for a place that was open and available.
On a Saturday?
I think that's correct.
And you know from your record review that the defendant on Saturday, January 22nd of 2011, told Mr. Ralph Monaco, for lack of a better phrase, the clerk at the Lock and Load gun store on Tampa Road in Hillsborough, that the reason she wanted a gun was because there had been home invasion robberies in her neighborhood and she wanted it for self-protection. Isn't that correct?
Yes.
And you would agree, would you not, sir, that that statement, that explanation, was not her true intent as to why she bought the firearm?
I would agree with that.
And you would further agree, would you not, sir, that her statement, her misrepresentation of her intent to Mr. Monaco at Lock and Load on January 21st of 2011 indicates that she was aware that the seller might not sell that gun to her if the seller knew her true reason for purchasing the gun. Isn't that correct?
I would agree with that.
So at least on some level, this defendant was able to understand that somebody else, in this case the person selling the gun, might think it was wrong for her to buy the gun to kill herself and the kids.
Absolutely correct, yes.
And that to that extent, she understood that members of society would view her purchase of the firearm with that intent to be wrong.
I would agree with that.
And you understand, don't you, Doctor, that a person in the state of Florida cannot be held to be legally insane if, even though they think their act is morally right, if they knew it was against the law or against society's values, then by law they're not insane. Don't you know that?
Judge, I'm going to object.
You may approach. A defendant who believed what she was doing was morally right is not insane if the defendant knew that what she was doing violated societal standards or was against the law.
I presume you're asking me that out of context of the particulars of this case.
I'm asking, do you know that to be the law in the state of Florida?
I wouldn't argue with that. I would agree that that's the law of the state of Florida. I might have an understanding of that that's more detailed.
Well, she had no reason to lie about her true intent behind the gun purchase if she wasn't concerned that she would be thwarted in her ability to buy the gun, would she?
No, I wouldn't agree with that statement. In fact, what I would say is that her state of mind was much more along the lines of, if people really understood this the way I understand this, they would agree with me. And that's crazy. That's out of touch with reality.
Well, if that's the case, there was no reason to lie, though. There was no reason to go across the county and lie. Would you agree with that?
No, I wouldn't agree with that, because she knew that people didn't understand it the way she understood it.
So she recognized that her belief was not commonly shared by others in society, right?
Yes.
Okay. That's the same thing I was asking you earlier. Would you agree or not?
No, I don't think so, because what she understood was that she didn't have a way to communicate her understanding of the situation to other people. Not that they wouldn't understand if they knew her point of view, but they could never appreciate her point of view.
Are you familiar with the fact that on January 29th of 2011, Dr. Eldra Solomon, with members of the Defendant's defense team, conducted a videotaped interview with her as she was in Tampa General Hospital a day or two after the murders?
I believe I'm aware of that, as long as it's the same videotape that I've seen, as long as there aren't two of them. I think that I'm familiar with the one you're referring to.
I only know of one.
Okay, good. Well, yes, I'm aware of that, and
Okay.
I've seen that videotape.
And is it a fact that during that videotaped interview conducted by members of her own defense team, that when asked if she had told Dr. Obregon about her intent to purchase a firearm to kill her kids and herself, she said she hadn't told a soul because they would have thwarted it. That plan.
I think she essentially said that. She also said some other things that were contradictory to that.
But that's how she answered that question, isn't it? She didn't tell a soul because she knew that they would thwart it.
Yes.
Thank you. And these two statements were within 30 days of the incident. The one to the defense team in Tampa General and to you, correct?
Yes.
And when you got that statement from her, you had introduced yourself and told her that you had been retained by her defense attorneys, and you were there to, I paraphrase, to investigate potential mental factors that may be pertinent to her defense.
That's correct.
Now, in your 30 years of clinical practice, you have prescribed at times, or have you, lithium and lamotrigine.
I have prescribed lithium and lamotrigine, yes.
And both of those are intended to treat mood disorders, to kind of moderate the highs and the lows.
That's correct. They're called mood stabilizers, and the goal of those drugs is to reduce the extreme highs, which are symptomatic, and the extreme lows, which are symptomatic.
And lithium itself is purported or held out to have the quality or ability to reduce suicidality. Isn't that correct?
Yes.
And in fact, for quite a few months before these murders, this defendant had been prescribed lamotrigine and lithium. Isn't that correct?
Yes.
Now, on every occasion that you prescribe these drugs, as a responsible practitioner, you would advise the patient not to consume alcohol with these drugs. Isn't that correct?
To some extent, yes, and to some extent, no. I'll explain, if you want, exactly how I do it.
Well, if you don't think a patient's going to be completely abstinent, you may allow them a drink or two. Is that fair to say, in layman's terms?
That's the right line of thinking. What I recognize as a treating physician is that if I tell somebody not to do something that they're going to do anyway, I might as well not tell them. Better to have a meaningful discussion with them about what makes sense and what the limits are, what they can do without hurting themselves, probably, rather than to practice defensive medicine and say, don't drink at all.
And you know that the consumption of alcohol with lithium and lamotrigine can have adverse or negative effects, correct?
Yes.
Just explain to the jury, please, what alcohol's effect on the central nervous system is in general.
The initial effect of alcohol, which many people are familiar with, when the alcohol level is increasing in the first hour or so, is a little bit of central nervous system stimulation for most people. People feel a little energized from it. They feel a little less anxious because of it. After a level has been established and maintained, people feel a central nervous system depressant effect. They feel less energy and less positive or optimistic. Now, unfortunately, like all drugs, alcohol has divergent effects, so that's a typical response, not a response that everybody gets.
Thank you, Doctor. Now, when alcohol is mixed with either of these drugs, it may have a synergistic effect. It may make the drugs have more of a sedative effect. Isn't that correct?
Yes?
And a synergistic effect, as I understand it, and correct me if, and I try to reduce it to the simple way that I can understand it, would be that the total is greater than the sum of the parts. 1 and 1, it would be 3. When you put the two together, it creates an effect more than each of the separate parts would in and of themselves. Is that about right?
I wouldn't disagree with that, yes.
You'd say it more eloquently, but...
It certainly, a synergistic effect means that they have an additive or more than additive, which would be the 1 and 1 equals 3 effect.
Okay. And in fact, if a person that has consumed alcohol is already depressed, the consumption of alcohol can exacerbate or make the underlying depression worse. Isn't that correct?
It can, yes.
And you certainly think that the defendant drank alcohol, and I'm talking about at or near the time of offense here in December and January. You would certainly think that, you certainly think that Ms. Schenecker drank alcohol in a way that fits into a pattern of alcohol abuse.
That's correct.
Okay. And among other records that you reviewed are the Winmore rehab records, correct?
Yes.
And on November 10th of 2010, when she was admitted to Winmore and was having an interview with the admissions psychiatrist, she told the psychiatrist that she was drinking 10 drinks of alcohol a day at that time. Isn't that correct?
I don't remember the specific number, but it's certainly consistent with what I remember, and it was what I would consider an excessive amount.
Showing Dr. Mayer pages 422 of the Winmore records. Sir, I'm showing you 2 pages of the initial admissions report of Ms. Schenecker. Would a review of that help you refresh your memory as to what she reported as a precise number of drinks that she had consumed? I had, for my preparation for trial, highlighted it, but feel free to look at anything you want.
Yes, it says that the patient had apparently been drinking 10 drinks or more per day, and that's excessive. My comment is that it's excessive.
Thank you. And you do recall, do you not, that throughout the Winmore records, she had reported having, as a result of her alcohol consumption and abuse, she had variously reported suffering from blackouts and morning shakes. Isn't that correct?
Yes, periods of lost memory and morning shakes.
She described herself to the Winmore mental health personnel as a heavy drinker, didn't she?
Yes?
And she, in filling out one of their forms, one of their inquiries, when in response to the question, how does she relax, her response was that she drinks and painkiller. Do you recall that?
Yes.
By the time you interview her later, however, what she has told you is that at around the time of the incident, she would drink only in the range of half a bottle of wine a day in the days leading up to the killings. Is that correct?
Yes.
Okay. Had you the opportunity to either speak with or read the deposition of the Schenecker maid, Michelle Frisco?
I did read her deposition.
And you understand from your review of the reports and everything that Miss Schenecker's husband, Parker Schenecker, was deployed and not in the country at the time of the murders. Is that correct?
I'm aware he was out of the home and deployed in the military.
And are you also familiar with Michelle Frisco's observation that she always saw more wine and beer bottles in the Schenecker home when Mr. Schenecker was away than she would otherwise when he was home?
Yes.
Okay. And you certainly think that Ms. Schenecker, in the care for her mental illness, would have been better off if she didn't drink any alcohol at all.
That is absolutely correct.
And furthermore, you'd agree that her use of alcohol had a negative effect on her relationship with her husband, Parker, and her children, Bo and Calix. Isn't that correct?
Yes.
And she, Julie Schenecker, in your view, knew that she would be better off if she stayed away from alcohol and that at times she drank too much.
Certainly, I believe that she knew that she drank too much. I'm not sure if she believed that being completely abstinent from alcohol was her best choice.
Well, doctor, do you recall, well, let me ask you this. Would reference to a prior deposition at a specific reference point perhaps refresh your memory?
Yes?
Handing Dr. Mayer deposition of April 17, 2013, page 88, directing your attention, you can read the full page if you want, but specifically at lines 14 through 16 inclusive.
And this, I presume, is my deposition.
You can look at the front cover, sir. It should have your name.
Yep. Okay, I've read that.
And in fact, the defendant did, at least it was your view, that the defendant knew that she would be better off if she stayed away from alcohol and that at times she drank too much. Isn't that correct?
That's an incomplete characterization of my answer here, and I wouldn't agree with it in isolation. I would agree with it in the context of the answer that I previously gave it, which I think is what I've given here in court today.
Didn't you say that statement that I just read?
I'm sorry, didn't I say that? Yes, I did. But I also said something quite contradictory to that in the sentence before. And
What was that, sir?
that she knew that that is drinking alcohol, wasn't a good idea, but that a couple of glasses of wine, she thought, in her words, would take the edge off. So she also said that sometimes it seemed to work fine in referring to alcohol. So I think to say that she knew that she would be better off if she never drank, and that's what I said, is inaccurate. What she knew was as a problem for her. Sometimes she thought it worked fine. That's what I said. Sometimes she thought it would be better if she stayed away from alcohol.
Well, you didn't say sometimes. You didn't qualify it in that regard in the depot, did you, doctor?
No, I said, what I said is that sometimes she thought it worked fine, and I also said that she said that she would be better off if she stayed away from alcohol, and that at times she drank too much. What I intended to communicate in that response in my deposition was that she had some ambivalence, that is mixed feelings, about whether drinking a little bit of alcohol some of the time might work fine.
Well, isn't it a fact, doctor, that her history of alcohol consumption and her resistance to alcohol rehabilitation and treatment was more than ambivalent? There are multiple indications in the record, are there not, doctor, that she had refused referrals for treatment, that when she was in Winmore she denied she had a problem, that she refused to acknowledge that consumption of alcohol was a problem for her, and that she would not accept continuing outpatient therapy or treatment for alcohol or drug rehabilitation. Isn't that all true?
Indeed, she had an illogical view of it. At times she believed that she drank too much and it was a big problem, and she acknowledged drinking 10 drinks a day, and at other times she seemed to act and make statements that indicated it wasn't a problem at all.
Well, isn't one of the biggest signs of an alcoholic that they don't acknowledge they have a problem with the consumption of alcohol?
Yes.
And in fact, the records from USF indicate that she had reported back in June of 2009, a year and a half before these murders, that she was drinking up to 7 drinks a day. Isn't that correct?
Yes.
And over the course of the following 4 months, from June to October of 2009, she variably reported 3 to 5 drinks a day, 5 to 6 drinks a day, 3 to 4 drinks a day, but the continuing theme throughout her all self-report from those months of June through October of 2010 was that she's drinking daily and not just 1 or 2 glasses of wine, correct?
That's certainly correct and consistent with alcohol abuse, as I've stated.
Was she underreporting those symptoms, doctor?
Which symptoms?
The alcohol consumption.
Well, I think she was unaware of the serious negative impact it had on her on a regular basis. So from that perspective, she was underreporting it. I think that she was probably reporting it accurately when she said she had 10 drinks a day. Whether she was always estimating her drinking history and reporting it accurately, I don't know. People typically underreport their alcohol consumption. She may have been underreporting it.
In addition to a history of alcohol abuse, Julie Schenecker had a history of non-compliance with her medication regime. Isn't that correct?
Yes.
And her non-compliance took different forms. They included not taking the right doses at the right time, or not taking doses at all, or consuming alcohol with the substances, correct? Those are all forms of non-compliance that she has historically participated in, or partook of.
That's correct.
You have indicated that her illness was biologically resistant, indicating that it was resistant to treatment because there's some physiological reason that the medications weren't working.
Yes, I have. That's correct.
Isn't it also possible, doctor, that her bipolar was resistant to medical treatment because she wasn't following the medical treatment? She wasn't taking the drugs at the right time, the right doses, and or she was drinking these great quantities of alcohol on a daily basis, which was counteractive to the drugs?
The inpatient hospitalization at Walter Reed certainly would indicate that there was a very strong component of biological resistance to her treatment. In the real world of treating patients in an outpatient setting, it is never that clear or simple. And indeed, the point you make is valid, which is that if she had perfectly followed the right regime of medication, it is likely she would have been better off. However, it is not that simple. For example, she, on one occasion, told her doctors that she didn't want to take any more medication because she had seen a show on Oprah about how people took too much medication and they didn't take responsibility for their illness and they didn't use non-medication treatments. Now, technically speaking, her not taking her medication because of a desire to avoid taking medication is non-compliance. But it is exactly the kind of initiation on the part of a patient that doctors want all the time. So compliance and non-compliance are not so simple as these are the doctor's orders, follow them all the time, don't do anything different than this. It gets very complicated to say why she's resistant. That there is a biological resistance is very clear.
But you can't tell whether that biological resistance would have rendered her medications in January of 2011 ineffective in the absence of alcohol consumption, can you?
Medical science has not reached that point. That is correct.
And you would agree that her non-compliance was not good for her mental health?
I would agree with that. She tried at times to do the right thing, but she was misguided.
In an interview with the defendant, she acknowledged to you that lithium took away her chronic craving to kill herself. Isn't that correct?
At times, yes, it did. I think at times it didn't, but she said that that was one of the benefits of the medication, particularly early on when she took it.
And she considered that a great benefit, didn't she?
She considered it a wonderful benefit, yes.
But she did acknowledge to you in an interview that she didn't like the fact that lithium also tended to take away the manias, in other words, to flatten out the highs. Isn't that correct?
Yes.
She didn't like it, as she told you, because she liked it when she was energized, happy, and interested.
Yes.
And so, as she reported to you, there were times when she wouldn't take her mania, or excuse me, she wouldn't take her lithium because she wanted to ride that high. That's my phrase, not hers.
Yeah, I wouldn't agree with ride that high.
That may be hyperbole, but she wanted to continue the emotions that she associated with mania, high energy, happiness, things of that nature.
I wouldn't quite agree with that either. What I would say is that the lithium brought her down, and she felt that there was a state where she experienced feelings similar to mania that weren't irrational, that weren't crazy, that weren't a problem, where she was energized and creative and engaged. And she did indeed indicate that there were times she didn't want to take her lithium because if she didn't, she'd get that positive edge. Sometimes we call that hypomania, that is below mania, and it is an almost universal characteristic of people with bipolar disorder and lithium, that they notice that the lithium does that to them and they don't like it for that reasons. And indeed, that was part of her experience.
And you really can't get a good feel based upon what she has told you, Ms. Schenecker that is, as to how compliant she was with her lithium medication regimen since she had been released from rehab, can you?
Since the Winmore rehab, is that what you're referring to?
Yes, sir.
Yes, no, I don't know. There are no lithium levels. That's really the only way we could know.
However, it is your opinion that lithium toxicity, that meaning too much lithium, well, excuse me, let me start that over. After she was arrested, she was ultimately hospitalized within a day or two because of elevated levels of Coumadin, the blood thinner, and lithium. Is that correct?
Yes.
Okay. And in that elevated levels of lithium were raised to such a degree that it was described as lithium toxicity. Is that correct?
That's correct. And in fact, that was a lithium level. It was subsequent to the time period you were talking about before, but there was a lithium level there. I think it was 1.9.
Well, that was after the events.
Yes.
Okay. And she had indicated to you that she didn't take any of the lithium until after the murders.
But she didn't overdose on it.
Right. So, in your view, the murders were not caused by lithium toxicity.
That is correct, yes.
Okay. You've read her writings in the spiral notebook, isn't that correct?
I have, yes.
And you're aware, are you not, doctor, that on an entry after the phrase M-O-N in capital letters, which I would take to be Monday, she indicated that what she had previously wrote was incomprehensible, that she was drunk when she was writing it, and that she had used all her leftover oxycodone. Do you recall that?
I do.
Okay. By her own account, written and otherwise, this defendant told you that she had taken actions, consumed substances that were adverse to her mental health. Isn't that correct?
I'm sorry, could you say that again?
Sure. By those writings, by her acknowledgement that she had drank to that extent and consumed her hydrocodone, that she acknowledged, she implicitly acknowledged that she was doing things that had an adverse impact on her mental health.
Yes, I would agree with that statement.
Now, concerning, while we're on the topic of lithium, you have seen the video where Ms. Schenecker has walked out from downtown Tampa Police Department out to a nearby police car, isn't that correct?
I have, yes.
And she's demonstrating some shaking of her head and her extremities, do you recall?
Yes.
And it's your opinion, is it not, doctor, that that shaking and those physical symptoms she displayed on that video were most likely caused by lithium toxicity and the psychic and mental shock of having some primitive awareness of what's happened.
Yes?
And you don't think that was a product of tardive dyskinesia, those symptoms you've seen?
No, I don't think they were.
Okay. Or mental illness?
No, not as a primary cause, no.
Okay. Do you consider Ms. Schenecker's concerns about in the days leading up to the murders that her husband wants to divorce her a paranoid delusion?
No.
Do you consider her concern that her daughter Calix may develop bipolar disorder to be a psychotic delusion?
No.
Did you see in the USF records an account over 2 or 3 visits where Ms. Schenecker described wanting to get impregnated by an ex-boyfriend during an upcoming October 2010 Iowa reunion?
I have a limited recollection of that. I may have to refresh my recollection.
And she actually, this was to Dr. Gabriel White and others in 2010. It would have been primarily in August and September.
What I recall is a reference to ideas about sexual promiscuity and misbehavior. I don't recall the details or the doctors that she said it to.
If Ms. Schenecker did report that she was contemplating...
Judge, clear, Coach.
Yes, sir. Absolutely. I'll move on while my partner looks
Sure.
at it. Yeah. Would it be a psychotic delusion if she had expressed that she wanted to wear a wig to her children's funerals following her arrest?
It might be. I'm not sure.
Isn't it correct from your review of the records, Doctor, that between 2007, when this defendant moved to Tampa, and the purchase of the gun on January 20th of 2011, that no psychiatrist or licensed mental health counselor documented a diagnosis that the defendant was suffering from a psychotic episode?
I believe that is correct.
In psychiatry, the practice, the clinical setting of psychiatry, great reliance is placed upon the patient's self-report by the practitioner. Isn't that correct?
Yes. As well as in all of medicine.
Well, it's distinct from other forms of medicine, is it not, that there are certain radiological tests that can verify a complaint of a broken bone, of a torn ligament, of a tumor.
Yes, that's certainly true.
Whereas in psychiatry, there's no such examination or no such test that can confirm what a patient is thinking or feeling.
For the most part, that's true, yes. Okay. Certainly not in the context of this case or these issues.
Okay. This defendant has, and at the time, throughout 2007 and 2011, significant cognitive and intellectual resources and abilities. Isn't that correct?
Yes.
She had the ability to participate and engage with and benefit from intellectual discussions about her condition with her treating examiners, didn't she?
Yes.
And in your view, she had considerable intelligence.
I would agree, yes.
She was fully capable during that time of 2007 and 2011, cognitively and intellectually, to report psychotic symptoms. Isn't that correct?
Now,
If they existed.
for the most part, yes, I would agree with that, as long as it's clear that my answer is limited to a very specific understanding of cognitive and intellectual that doesn't include psychological.
After you spoke to her, and after she was charged, you spoke to her, and she told you that she had underreported her symptoms to mental health professionals. Isn't that correct?
Yes.
Nowhere in any other documentation that you have seen of medical records from any other provider had she made such an admission, had she?
I think that the example that I gave, where she acknowledged that she was having psychotic experiences while watching television in the hospital after the fact, is in fact a very clear acknowledgement that at the time she was experiencing them, she either underreported them or didn't report them at all.
Are you assuming for that answer that there was somebody there as the delusion or hallucination occurred that she could have reported it to as they were happening?
I'm presuming she could have reported it sooner than she did, yes.
There's no temporal proximity described in that report as to the date it occurred and the date that she reported it, is there? There's no indication in that record as to any delay.
I think there is. I think it says after, and I think the clinician's commentary is clear that the patient is reporting something not in the context. This is my interpretation, my understanding, and I would read the record if necessary, that she's reporting it after not reporting it.
That's your interpretation from the word after in the context of that record, isn't it?
That's correct.
Okay. Because a record doesn't describe any delay in terms of time or days other than the word after.
That's correct. Doesn't say 3 days later or 2 hours later or anything like that.
After could have been 30 seconds later, couldn't it?
I think it's very clear it wasn't 30 seconds later.
Very clear would be your interpretation.
That's correct.
All right, doctor. USF records don't explicitly include a particular period of psychosis, isn't that correct?
They do not specifically report a psychotic episode that they observed and treated. That is correct.
It wasn't until after she was charged with 2 counts of first-degree murder that she directly acknowledged to a mental health professional that she had ever underreported it out of her own mouth, under her own description, correct?
Yes.
Now, she explained to you that she underreported her symptoms because she wanted to avoid having her medications reviewed. Isn't that correct?
Yes.
Isn't that an indication to you, doctor, that she was willing to knowingly either deceive or withhold information from mental health professionals to avoid a result that was not desirable to her?
I would not agree with that statement as you made it. I would say that she was willing to do that in the belief that her best interest was to withhold information in order to self-manage her medications. And I would disagree that it was in her best interest, but I would say that her intent was that she believed she could manage her medications better than her doctors. And that's a bit different than what you've just said.
The bottom line is she acknowledged she underreported because she had a desired course of action she wanted to take contrary to medical advice. Isn't that correct?
No, it's not correct. She underreported because she believed that she could manage her medications better if she reported some symptoms with some intensity to her doctors and others with a different intensity.
Isn't that a form of manipulation of medical treatment? When you're reporting sometimes this and sometimes not this, aren't you manipulating the care provided by the mental health practitioner by the information you report, intentionally report or under-report?
I'm not sure that I would characterize it as manipulation in the context you're describing it. It is a nearly universal experience of doctors and almost all patients that it's a pattern of behavior that occurs frequently. It's associated with diet control, it's associated with alcohol consumption, it's associated with medications which people know their doctors think they should take, but they have bad side effect. So to call it a manipulation in the context you're offering it, I would not agree. In some respect, if we go with the dictionary definition, yes, it's a manipulation. It's a part of the usual interaction between doctor and patient, which may not be optimal or ideal, but is nearly universal in doctors' treatment physicians' experience.
Doctor, you didn't do any psychological testing in this case, isn't that correct?
That is correct.
Because in your view, none of the tests are precisely or specifically directed toward the legal questions in this case, isn't that correct?
Yes.
And in your view, at best, those type of instruments anyway are only effective in the range of 70% of the time.
That's correct.
Okay. Moving to her initial admissions evaluation to treatment by the USF clinic, isn't it a fact, doctor, as you recall, that in her initial interview with Dr. Megan Ross, she reported, as a result of her mental illness, a history of periods of sex, drugs, violence, and acting out?
Yes.
And along those lines, isn't it true, doctor, that on an emergency services screening examination at Winmore at the time of her admission, when the question on the form posed to her homicidal plans, thoughts, or previous attempts, she hand wrote, at one time thought of turning on car with motor running and her kids? Isn't that in the records?
Yes.
And the Winmore admission was in November 10th of 2010, isn't that correct?
Yes.
Okay. She wasn't actively psychotic at that time, was she?
Not that I know of, no.
But she reported having thoughts, homicidal thoughts, plans, or intents of killing her kids through leaving the car running and then suffering a death as a result.
Yes.
So this idea of killing her kids isn't something that she had thought for the first time in the days between the gun purchase and the actual murders. Isn't that correct?
Yes.
Her consumption and desire for hydrocodone, in your view, amounted to abuse. Would you agree?
It was a prescribed medication, and I believe that she took it in a manner which was contrary to the prescribed intent. I would therefore consider it abusive.
Because the prescribed intent was for treatment of pain, and she took it to produce a certain mood or mental health effect.
Or to alleviate what she called brain pain. And brain pain was not, and I think she understood that brain pain was not the purpose of the medication.
And in your view, her consumption of opiates probably contributed to her depressed state of mind at and near the time of the offense. Isn't that correct?
Yes.
You have spoken about, in general terms, her mental health in the months of 2009 and 2010, and that there had been some symptoms of bipolar as expressed through her gambling. Is that correct?
Yes.
And in fact, she had a period of greater than a year of gambling away substantial monies at Hard Rock Casino, unbeknownst to her husband. Isn't that correct?
Yes.
At one point, according to what's documented in the medical records, she was going twice a month and spending over $1,000 a month, correct?
I recall that, and I believe that's correct.
And she reported, as far as her gambling in 2009, that she even dipped into some type of retirement fund and withdrew $1,700 and went through that. Isn't that correct?
I think she said she expected she'd probably end up using it for gambling.
And in the following note to not the retirement fund and withdrew $1,700 and went through that. Isn't that correct?
I think she said she expected she'd probably end up using it for gambling.
And in the following note to not the psych.
I looked at a lot of emails that went back and forth among the family.